All rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Alan Lawson, Chief Judge, is presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. As announced, I'm Alan Lawson. To my right is Judge Tom Sawaya. To my left, Judge Brian Lambert, rounding out the panel. We have two cases for argument today. The first is a civil case. Each side will have 20 minutes. If you are the appellant and you let me know how much time you'd like to save for rebuttal, I will set the clock so that the light will turn yellow when you're in your rebuttal time. It'll be green initially. It'll turn yellow when it's red, your time's expired. But it's up to you. You can continue to use your rebuttal time or you can save it. We'll leave that up to you. For the criminal case, each side has 15 minutes. The first case on the docket is OLSON versus PICKETT Downs. And whenever you're ready, counsel.
Thank you, Your Honor. Good morning. My name is Peter McGrath. I represent the appellant, Stuart Olson. I'm here with co-counsel, attorney James Hauser. Mr. Olson's in the gallery over there to my left. Thank you. It's a pleasure and an honor to be here this morning, Judges Sawaya, Lawson, and Lambert. What I'd like to do is start with a brief, very brief statement of the facts and procedural history. The only fact I want to bring to the appellate panel's consideration is that in March 1996, the appellant, Stuart Olson, buried a 150-foot-long, 15-inch corrugated metal pipe in his front yard. He leveled off his front yard with some soil and sod, and that's it. That's the only fact I wanted to bring out, what happened back in March 1996. Let's flash forward a little over 15 years later, in November 2011, when the association instituted the instant action. The association, PICKETT Downs Unit 4 Homeowners Association, I'll simply refer to as the association or the appellee. It filed in November 2011 a 4-count complaint against Mr. Olson to force him to remove the culvert. Count 1 of the association's complaint was an action for injunction. Based on certain covenants and restrictions, the association sought relief which would require Mr. Olson to remove the culvert and restore the swale or ditch that had been there before. Count 2 of the association's action was was an action for declaratory relief. Here the lower court was asked to construe the scope and meaning of the covenants so as to allow the association to come upon Mr. Olson's lot and excavate and remove the culvert. Count 3, among the 4 counts of this complaint, is unique. Count 3 was a common law action based on private nuisance, where the association sought removal of the culvert and also sought an award of damages. By the way, count 3 is the only count of the 4 counts of the plaintiff's complaint where attorney fees were not sought. Fees were sought under counts 1, 2, and 4, which gets me to count 4, an action based on interference with easement, wherein the association sought, once again, an injunction permitting the association to come upon Mr. Olson's lot to excavate and remove the culvert. Mr. Olson filed an answer and defenses to the association's complaint, and Mr. Olson pled for an award of attorney fees under counts 1, 2, and 4, just as the association did. The lawsuit came to issue sometime in 2012. The parties litigated for 4 years. It culminated in a 4-day non-jury trial conducted between September 15 and September 18, 2015, after which the court rendered a final judgment. The lower court's ruling was very favorable for Mr. Olson. The court ruled that based on the statutes of limitation having expired, a 4-year and a 5-year statute, a 10-year statute of repose, and the doctrine of latches, that all relief sought by the association under counts 1, 2, and 4 of the complaint was denied.
One of the grounds that you're asking for fees is under paragraph 14 of the restrictive covenants, and as it applies through the 571057. reciprocity statute?
That's right, yes. We have a, if you will, an old-fashioned attorney fee provision found in these covenants recorded in 1986, which provided a prevailing party attorney fee only to the party securing relief.
Do you place any significance on the fact that the declarations were recorded, or the restrictive, I'll call them restrictive covenants, were recorded in 1986, and 57-105-7 says the subsection applies only to any contracts entered into on or after October 1 of 1998?
Well, Judge, that's a good
1988,
point.
excuse me.
And the point is well taken. And it may be that 57-105 may not apply in this context, but regardless, both parties did plead entitlement under the relevant Homeowners Association statute, section 720.305, subsection 1. So the prevailing party attorney...
Let me just my clarification. Would 57-105-7, your client didn't acquire the home until 1993 in the subdivision?
That's correct. He
Would
acquired title of
would that, in essence, be the effective date of the declarations vis-a-vis any claim that he would have under the 57-105-7?
Possibly, for it's a legal argument I haven't considered. But regardless, there is an available statutory basis for an award of attorney fees in this case. With respect to the contractual basis for an award of attorney fees, yes, we would still consider 57-105-7 to be applicable, which is also mandatory. But regardless, Mr. Olson obtained a very favorable judgment. All injunctive relief was denied under all 4 counts. Count 2 of the association's complaint was deemed moot because the court did not need to construe the scope and meaning of the covenants and restrictions at question, because regardless as to their enforceability, or regardless as to whatever provision of that declaration Mr. Olson may have violated, it didn't matter. Too much time had gone by, over 15 years. The injunctive relief sought by the association in its common law nuisance claim, count 3, was denied. But here's the rub, and here's really why we're here today. The court did award the association $100 in nominal damages under the common law nuisance claim. The lower court erred, however.
Let me ask you this question. Really the dispute primarily, I think, hinges on whether you were the prevailing party, and there's the significant issues test that the Supreme Court's laid out that you're familiar with and you briefed thoroughly. And then there's also another test from the 4th DCA that you laid out where you look at the claims for which attorney's fees are available and ask if the party prevailed on those particular claims. And my question to you is does it matter as a practical matter? I mean, is there any difference in the attorney's fee award whether you use the general test or whether you use the 4th DCA analysis?
Well, look, it may go to the issue of amount, which test is used. As we see it, the only test which should really apply in circumstances like this would be the test set forth in Lockrane and numerous other 5th DCA cases. Very simple proposition that if Party A prevails on a count that permits attorney fees, but Party B prevails on a count that does not permit attorney fees, Party A is nevertheless still entitled to attorney fees for those counts allowing for attorney's fees. And here, there's no argument about count 1. Mr. Olson prevailed on that count. Opposing counsel hasn't even challenged that proposition in the answer brief. In fact, he prevailed on all counts that permitted attorney fees, counts 1, 2, and 4.
Why do you say you're entitled to costs for count 3? Would you explain that to me if we're going to apply the prevailing party standard for that count? You're seeking costs for that, right?
Well, it depends on which standard we're going to approach. Part 1 of my legal argument was going to relate to Lockrane Engineering and its progeny. Part 2 of my legal argument was going to relate to the significant issues test. Either way, in this 5th DCA, costs are determined on the same basis as attorney fees. And when you look at count 3, which was a count for mainly injunctive relief, the association was never serious about its claim that it had incurred damages as a result of Mr. Olson's culvert. They admitted it before, during trial, that damages were a non-issue. So the important issue with respect to count 3 had to be the injunction that the association was seeking. This is what this case was all about, causing Mr. Olson's yard to be excavated and to have that culvert removed. So, moving on, it's fairly clear.
Well, as to the costs, I mean, isn't your argument is that you're prevailing on the significant issues? I mean, the injunction is the significant overarching issue in this case, isn't it?
Yeah, looking at the issue of costs, which is based on the same test that one would do for attorney fees in a significant issues test, if we're going to focus on count 3, it's fairly clear to me, at least, that the main relief sought by the association was the injunction.
So you believe that the trial court abused its discretion in not awarding costs?
You could say so, because I believe the significant issues test is the test used for determination of costs. And costs is a fairly significant quantum, a significant issue in this appeal.
Well, I think you cited a case in your brief, this Granoff versus Seidel, that actually that guy down there wrote. So I thought...
It's a great case, very helpful to Mr. Olson on the issue of costs, where the court in that case...
You're saying it was well written?
Is brilliantly written, if I may say so, because you had to parse through so many facts.
That's right.
Yeah, you had the holder of the
People get lucky sometimes.
well, let me put it this way: the holder of the tenement subject to the easement got a lot out of that, a lower court decision. The holder of the dominant tenement got a lot out of that. But the key in that case was rights of passage, and the holder of the easement got his rights of passage, and the impediments were removed. That was the main issue in Granoff recital, not a question of whether there was irrigation or a post office box. It was an issue of whether or not this individual would get his easement, and he did. He was entitled to traverse that land unimpeded, and in the end, this court determined that costs went to the holder of the dominant or the subservient tenant. Regardless, we have Lockrane Engineering, we have Rockledge Mall Associates, we have Seibert v. Combs, we have the 4th DCA following that basic rule about when party A prevails on account and party allowing attorney fees and party B doesn't. It's an automatic, it's a non-discretionary issue. It's a different test than the significant issues test when it comes to the attorney fees, because there's no question that Mr. Olson prevailed on the counts where attorney fees were at issue. I could go into detail with respect to some of those cases, but I think this panel is familiar with them. Count 1, prevailing party attorney fees. Count 2, prevailing party attorney fees. Count 4, prevailing party attorney fees. Mr. Olson prevailed on all 3. Now, the appellee in their answer brief really hasn't challenged that. They have not challenged that foundational argument which we presented in our initial brief. Instead, they sort of quibble around the edges, arguing that count 4, where they really weren't seeking attorney fees in count 4 even though they pled for them, arguing that count 2 isn't a win for anybody because it was rendered moot, but it wasn't rendered moot because of some act of God. It was rendered moot because of defenses that Mr. Olson raised relating to the statute of limitation and repose and latches. So I guess the simple point I want to make is that it appears that Mr. Olson is clearly entitled to an award of attorney fees. Maybe there's an issue as to the amount of those fees, whether the issues are intertwined. That'll be a decision for the lower courts to figure out if this case does in fact get remanded. If this court, this panel, this esteemed panel, were to decide not to follow the precedents of Lockrane Engineering, Rockledge Mall, Seibert v. Combs, Freeman v. Lauderdale, Avatar Development Corporation, and apply the same test that the lower court applied, and try to look at the attorney fees issues from the perspective of the significant issues, I think it's fairly clear that Mr. Olson prevailed on the significant issues test as well. Once again, all of the injunctive relief sought by the association was denied under every count. The issue of damages was a non-issue, admitted by the plaintiff's representatives. The award of $100 in nominal damages certainly couldn't be considered significant on that basis alone.
Well, the court found there was no compensatory damages proven. Wasn't that true?
That's right. And
that's another pebble on your side of the scale, isn't it?
Yeah, there was no compensatory damages, but the court did find a nuisance and awarded nominal damages. But like I said, that was never an issue. The plaintiff admitted at trial, all of its representatives, that Mr. Olson's culvert never caused any sort of compensatory or other damages. And it's difficult to argue with a straight face that by recovering nominal damages of $100, but obtaining none of the injunctive relief, that there was somehow a tie. But that's what the association is arguing in its answer brief, and what we've suggested in our reply brief is that we might ask counsel for the appellee whether they're satisfied with this result, whether they're happy with the $100 nominal damages award and the denial of all injunctive relief. I can tell you Mr. Olson is pleased that his front yard has remained intact and will continue to do so. And this helps us even more, and this is the main case cited by the appellee in their answer brief, the Sorrentino versus River Run condominium case. surprising that they would cite it as their main case, because it's rare that you meet something that is so on all fours with respect to the facts. And, you know, esteemed panel, I did forget to reserve 5 minutes for rebuttal, so if it's not too late to do so.
The light will turn yellow when you hit 5.
Oh, yeah, very good. So, Sorrentino, the condominium association is upset that one of their unit owners installed tubular skylights in their unit without prior approval. They sued. The owner defended on the basis of an energy saving statute, section 163.04, that allowed such energy saving devices to be installed without approval from organizations like a homeowner association. The owner prevailed. That statute, by the way, does have a prevailing party attorney fee provision. The trial court denied attorney fees because of the posture of the case and the way the case worked itself out. But this court reversed the lower court, ruling that Sorrentino's prevailed on all of the significant issues raised. The objective sought by the association in that case, the removal of the skylights, was completely denied. This makes Sorrentino very similar with respect to the dynamic of the relationship between an individual homeowner and the Common Interest Realty Association or Homeowner Association. Mr. Olson was not required to the culvert. He clearly prevailed, and he's entitled to attorney fees on the same basis, if we're going to apply the significant issues test, as that applied by this court in the Sorrentino case. So that's where we are with this right now. I'd like to save a few moments for rebuttal. There's certain arguments raised by the opposing counsel in the answer brief, which I think would be appropriate to address on rebuttal. Thank you.
Good morning, Your Honors. Ted Estes, I represent the appellee in this case. The number one driver in this case, once the suit was filed, was the issue of whether or not the covenants were binding on Mr. Olson. That drove the discovery in the case, it drove the motion practice in the case, and it drove the trial in the case. Is he a party to the contract? That was the biggest issue, and Mr. Olson, on every occasion, denied that he was a party to the contract, denied that the covenants were binding and restricting on his property, denied that he had any obligation to be bound by the covenants and restrictions or anything from the association.
He argued that at trial?
Excuse me?
He argued that at trial?
They argued it throughout the case, yes, sir.
But apparently the judge didn't rule to that effect.
She did not. She found that
ruled otherwise.
She didn't
Ruled
rule
on other issues.
She ruled on other issues. She found that count to be moot, but nonetheless, this is a contract that is open. It's executory in nature in that the covenants and restrictions are in the public records. There's still an ongoing, continuing issue.
Your consistent position was that he was bound by the covenants.
That's correct.
Okay.
Yep. Yes, sir. We maintain that position. But Mr. Olson is the one who's now asking for recovery. He's asking for benefit under those covenants. He's asking for attorney's fees.
But the judicial estoppel doctrine that you raised, I mean, if he had prevailed on that, if the judge said, yes, these are not binding upon you, and then he turned around and said, well, I want fees under them, wouldn't that be the applicability of that doctrine and not what you're raising here today?
I think that's the strict reading of that doctrine, but I think that doctrine
What's the loose reading of it then?
Well, I think it can be read broader than that. I think this is an equitable issue that can be addressed by the court. And the equitable issue is here's somebody who denies being a party to the contract. They say he is not a party, he's not bound by the contract, he is not a party to the contract.
And that's sort of where I was going. If we're going to just change the judicial estoppel doctrine and make it some kind of equitable thing, then I don't know why it wouldn't equally apply to you and your ability to argue that they shouldn't get fees because you've maintained consistently throughout the litigation that the covenant did apply. So, I mean, if we're going to be fair in saying you can't argue something because you took a different position, we ought to be fair and say you can't argue it either because you took a different position.
Well, I think the difference is they're asking for relief under this contract. They're saying they're now saying ostensibly there is a contract that we're a party to and we want the benefits of it, which is not his position. It's never been his position, and I submit it's not his position here today, that he's a party to that contract, that he's bound by those covenants and restrictions. So for him to say, I want the benefits of that contract.
Well,
and-
okay, other than the judicial estoppel doctrine, which does not apply because they did not prevail below on that issue, which is what the doctrine requires, are there any other basis for denying fees under these circumstances? I mean, is there any case out there where someone did not prevail on an argument like this, and yet they were denied fees based on the fact that they argued below that the contract didn't exist?
I don't think there's any case exactly on point, Your Honor. I think the difference is, in our case, the trial court did not rule on count 2. Every other case that I've looked at, the trial court has ruled on the issue of whether there was a contract or not. So there was actually a ruling. In our case, which I think distinguishes it for purposes of certainly my argument, that the trial court did not make that ruling. She left it open, but nonetheless, Mr. Olson is trying to get the benefits of the contract, and he should not be able to get the benefits of the contract when he denies its existence and denies that he's a party to it. And then with respect to the significant issues question, the trial court, essentially found that there was a tie. And I think the trial court was looking at not just counts 1 and 3 and 4, but I think she also was looking at count 2, which again was the primary driver in this case. Can't lose sight of the fact that that's what drove this litigation, is whether or not those covenants were binding on Mr. Olson's property.
What drove the litigation was the homeowner association wanted the swale fixed so it wouldn't flood, right?
But that's what started the litigation, Your Honor.
That's what you wanted to have. That's what
Yes,
you
sir.
wanted to have happen, because that's what you pled in each count.
That's right. That's what, not in each count, but
Or you
that's
wanted
what-
injunctive relief to, in essence, have either the homeowner fix the swale so it wouldn't flood, or to give you, the homeowners association, the right to go on the property to fix the swale. Isn't that in the
Well, I
wherefore
think-
clause of each of your
I think
counts?
count 1 was clearly injunctive relief that we sought, and count 4.
But you do say injunctive relief in each of your wherefore clauses of all 4.
I don't think we do in count 2, Your Honor.
Okay.
I can get it. I don't think we asked for injunctive relief in that count.
You have it there?
I do, yes, sir. Would you like me to read it?
In the wherefore clause.
It says, wherefore, plaintiff Pickett Downs Homes Homeowners Association Unit 4 demands judgment by the tort declaring the roadway drainage swale is located within the 70-foot roadway easement, that under the declaration, plaintiff is entitled to determine that the roadway drainage swale requires maintenance and upkeep, that plaintiff is entitled to access defendant's property to perform maintenance and upkeep of the roadway drainage swale located within the roadway easement, and for an award of attorney's fees, costs, and for any other relief the court deems just and equitable. So we were not asking for injunctive relief. We were asking for the declaratory relief that said we had the rights that were elicited under the declarations and covenants. But as I said, the primary issue that drove the litigation was whether or not these covenants were binding on the land. And I think the trial court, in deciding not to decide, was looking at that as a tie, a wash, a push, whatever you want to call it. And I
So if
think
the judge would have declared that these restrictive covenants are binding upon the land, but you don't get to get relief to go on and fix the swale, or you can't make the homeowner fix the swale, you'd have thought that, well, we won.
Well, I think if the court had found in our favor on count 2 and found that the covenants and restrictions were binding and enforceable on the property, and that we had these rights that are elicited in the covenants, then I think on a going forward basis, we would have had the right to maintain the easement. That may have been a future dispute as to what that meant at some point, but it was not, we weren't seeking injunctive relief for what was existing, like we did in count 1 and count 4. I agree, we clearly asked for...
How would you prospectively enforce that if it was determined on the other counts that laches or statute of limitations or repose bars your claim to get any type of relief regarding the fixing of the swale?
Well, the swale could cause future problems. that required maintenance. There could be that culvert could deteriorate and collapse and require maintenance. And I think if the court had ruled in our favor, had ruled on count 2 and in our favor, that would have given the association the authority to go in there and perform that maintenance in the future. So I think the trial court was looking at, not just count 1, not just count 4, not just count 3, but also count 2 in determining that there was not a prevailing party in the case using the significant issues test. And the standard of that is an abuse of discretion, not de novo.
Do you believe the court erred in finding count 2 was moot then? Because apparently the issue that you wanted decided that was significant to your client is still
Well, I think
out there.
we would have preferred that she had ruled on count 2. We would
File a
have,
motion for rehearing saying, hey, you really need to rule because we need to have this decided. It's really not moot. We need to have a determination whether this declaration or restrictive covenant is binding upon Mr. Olson.
we did not. The trial court, found one of the issues raised by the defendant, Mr. Olson, was the issue of standing. And part of that standing issue was whether or not the covenants and restrictions were binding on his land, whether he was a party to that contract. The trial court ultimately found standing based upon our ownership of a tract of property that benefited from the easement, so that this tract C, which was a retention area, had access to the road easement, was part of that. So she found that we were the beneficiaries of that easement, a dominant tenement, and that Mr. Olson, as one of the lots in the community upon which the easement ran across, was a servient tenement. And so that's how she found, and that went to counts 3, primarily went to counts 3 and count 4 on the easement issues. We believe the trial court has discretion to determine who, if anyone, was the prevailing party, and I think that's the cases that the Sorrentino case and several other cases, including Merchant's bonding case, where the 5th DCA previously rejected that mandatory rule that required the trial court to designate a party as prevailing. And I think if you go back to cases like Lockrane, those are the pre-significant issues tests, and the subsequent cases are that the trial court's not required to designate a party as a prevailing party. And in this case, based upon the significant issues, the trial court did, in fact.
Let's assume the nominal damage award was $1 instead of $100.
Okay.
And so at the start of the litigation, you said, okay, the end result of this case is there's going to be no injunction, and the homeowners association is going to get $1. I'm having a hard time grasping that your client would think, well, that's a tie coming out of this case.
Well, I think that.
Or your client would want to file suit to think that that's going to be the end result if he or it had a crystal ball saying, this is what's going to happen years down the road after a 4-day trial.
I think at the end of the 4-day trial, at that point, again, the litigation really changed to fighting about a culvert which had nominal cost. I mean, we're not talking about a significant amount of money at all. We're talking about the issue became, do these covenants bind the land? That's what drove the litigation in this case. That's what required a 4-day trial. That's what required multiple motions for summary judgment, motions for every motion you can
And you
imagine.
didn't win that issue. If that's the driving force, you didn't win that issue.
We didn't lose it, and that issue was raised by Mr. Olson, not by us. Mr. Olson raised the issue, hey, the covenants, I'm not a party to this contract. That's what drove it. We didn't lose it. We didn't win it. If we had lost it, there wouldn't be any issue about attorney's fees because there would be no contract. That would be crystal clear under all your interpretations of the case law. If we had won, then we would have been the prevailing party on count 2. And it would have been perfectly clear that the trial court judge would have had the, I think, authority to find that there was if you want to call it a tie, or no prevailing party in the ultimate case. So I think either way you look at how the trial court would come down on that issue, we wouldn't be talking about attorney's fees here in this case.
Just so that I understand, so you would agree that under Loughran and the cases that the other side cites, that they would be entitled to attorney's fees on counts 1 and 4, that they were the prevailing party there, unless we find that judicial estoppel applies?
In count 1, Your Honor.
In count 1.
But count 4, I don't think there isn't a basis for attorney's fees, and we pled them, there's no doubt about that. But I believe ultimately, whether you plead it isn't the determining factor as to whether or not there's entitlement to it. And that was on a private easement based upon the plat. That's how the court ruled. That's how it's framed in the pleadings. And so I don't believe that there is an attorney fee provision that would be applicable in count 4. Count 1, absolutely, there is an attorney fee provision in that count. We lost that count December of 2012. Is when the court entered summary judgment on count 1 for the basic breach of contract.
Well, could you have lost on count 1 and won on count 4 and then been able under count 4 to go forward and repair or fix the swale? I mean, that's in essence what you were asking to do on count 4. You were saying, well, we have this ingress, egress, or utility easement, and through those platted easements, we want to have the right to go onto the property because the swale is impairing the ingress and egress to have it fixed. So, I mean, it's kind of an indirect way of saying, as I read it, that you're trying to get relief through the restrictive covenants.
I think they're different causes of action for the same ultimate relief. I think one has an attorney fee provision in it and one does not. One is through the covenants and restrictions and one is through the easements that are on the plat.
Wouldn't it be inconsistent though for the judge to have said you have no relief under 1, but you're entitled to relief to go get injunctive relief, and I believe you actually pled injunctive relief under 4.
We did, yes, sir.
Okay,
Yes.
I knew it was there somewhere. So how would that happen? I'm trying to get a grip on this as to, you're either entitled to go onto the swale or not, aren't you?
Well, I think the court could have ruled in Mr. Olson's favor that the covenants and restrictions didn't bind the land, could have found in our favor on count 4 on the private easement that's on the plat.
That was somehow affecting the ingress and egress of people on the property?
Sure.
That's the platted, it's ingress and egress.
Yes, it's the roadway
Right.
on the plat, yes, sir.
Okay, and so the condition of his property is affecting the ability of people to travel in and out of that area of the subdivision?
To the extent it causes flooding, yes, sir. And we put on evidence of that. And ultimately, the court found, in our favor on their affirmative defenses, but for the statute of limitations and the statute of repose. I don't really think the statute of repose applies, but the statute of limitations did, and so that's why we didn't appeal that issue. So yes, I think the court could have
They
ruled.
also determined laches applied?
I think that, yeah, I mean, it could. But I think clearly the court could have entered a judgment in our favor on count 4 and not on count 1, depending upon, if the statute of limitations argument is consistent between the two counts, I'm not disputing that, but take the statute of limitations argument out of it. If Olson had prevailed on the covenants him not being a party to that, the court still could have ruled in our favor on count 4, and I don't think the attorney fee provision would have been applicable.
If the attorney fees incurred are all intertwined amongst the causes of action, would they still be entitled to fees for the entire action if it was just a prevailing under count 1, which apparently you're not challenged?
I challenged it based upon the trial court's, significant issues, but standalone, that was December of 2012. So no, I don't think they'd be entitled to any attorney's fees throughout the rest of the case based upon that count and the attorney fee provision in that count. Any other questions?
Any questions? No, thank you very much.
Thank you.
Thank you for some time for rebuttal. I appreciate it. I'll try to be brief. Just a few key points. Law Crane Engineering and its progeny is still a good law in this District Court of Appeals and throughout the state of Florida. My client clearly did prevail on those counts, which did permit prevailing party attorney fees. With respect to this notion that Judge Chase somehow offered a relief to the association by not ruling on the issue as to the enforceability of the covenants, I just simply point out to this panel that there's a reason why Judge Chase didn't need to rule on the issue as to the enforceability of the covenants or rule as to whether any provision within those covenants was violated or which authorized the association to enter upon Mr. Olson's lot. That's the passage of time. Too much time had gone by. The lower court made it clear that in this case the appellee was guilty of delay in asserting its rights. It didn't need to reach the covenants because why would the court use that judicial effort in a meaningless exercise where it would have no impact on the outcome of the case? Because, as I said, the statute of limitations, repose and latches clearly barred the plaintiff's act.
Can you address the argument that there's no basis for an award of attorney's fees on count 4?
Yeah, sure. It's simply a matter of viewing the plaintiff's complaint.
I mean, they did plead them, they acknowledge that, but they're arguing that there isn't a basis because...
Let me put it this way. Count 4 of their complaint is labeled an action to enjoin interference with a recorded easement. At the beginning of the complaint, the association set forth facts common to all counts. I presume that includes count 4. And those counts incorporated into count 4 included paragraphs 3, 14, 19, and 21, which invoked the declaration as a basis for the relief sought in count 4. And when you look at the relief, when you look at the grounds for relief stated under count 4, the appellee stated as follows: defendant has modified the roadway easement on his property without the association's consent and failed and refused to allow the association to use and access to the drainage swales. Now, if there's arguing that count 4 is based solely on the plat, which is in the record, there's no reference in the plat to a homeowner association. There's no set of covenants and restrictions described in the plat. Clearly, count 4, on its face, incorporates provisions of general allegations, which refers to the declaration, and then asks for relief allowing the association to do things, which it certainly wouldn't be able to do without the restrictions. The plat is bereft of any reference whatsoever to the association or any rights and obligations of the members with respect to the association. So that argument just doesn't work. It does help us that count 4 has a prevailing party attorney fees provision, that the plaintiff pled. It goes to the issue of cost mentioned by you, Judge Sawaya. Clearly, Mr. Olson prevailed on counts 1 and 4. That, regardless of what you want to do with count 2, regardless of what you want to do with count 3, he clearly prevailed on 2 counts of the plaintiff's complaint, which would entitle him to an award of costs. I guess the final point I want to briefly make with the issue of estoppel in mind, clearly the lower court took no action with respect to the defense related as to the enforceability of the covenants. It didn't need to. There isn't a case anywhere in the state of Florida which would hoist a litigant by its petard by something it pled. There has to be action secured by the court in order for an estoppel to arise. That's the whole point. You stake a position upon which the court relies in doing something. And here, that never happened. The court didn't do anything with respect to this defense. So I think it's fairly clear that Mr. Olson is a prevailing party. With respect to count 2, the declaratory statement action, once again, going back to the idea that this dismissal didn't occur as a result of forces outside the control of the parties. The dismissal of count 2 occurred as a result of Mr. Olson raising these defenses. Count 2 became moot because of the expiration of the statutes of limitation and repose and latches, not because of something outside the control of the plaintiff or the defendant. And on the basis of that dismissal, there is an argument to be made that that dismissal is an adjudication on the merits based on defenses raised by Mr. Olson, and Mr. Olson could very well indeed be considered a prevailing party under count 2 on that basis. So that's all I have for you this morning. It's been a great experience coming before you. Thank you.
Thank you both for your arguments. Appreciate it.